This is Professor Porter. We're doing frequently asked questions that we get on the YouTube channel having to do with evidence. Here's a popular one. What's the difference between direct and circumstantial evidence? This is one that's often mistaken from TV and the movies because you'll hear oftentimes counsel argue, defense counsel in a criminal case may argue, the evidence here is all circumstantial to make it sound like it should be weighted less. The answer is direct and circumstantial evidence can count equally. Direct evidence often means evidence that comes from a witness. A witness says it so. I saw the person leaving the convenience store at that time. That's direct evidence because the witness says it so. Circumstantial evidence means something where the jury hears it, but they have to make some inference. They have to take what they hear and infer something to get to the actual conclusion that the attorney hopes that they make. The person stepped outside of their door, they saw that everything as far as they could see was wet, so they inferred that it rained the night before. That's a popular one that you hear in jury instructions that people hear at trial when they serve as jurors. So one requires some kind of inferential leap, the other one requires direct evidence. But if you think about it, testimony as direct evidence. But if you think about it, even testimony as someone explains something to you, even if they're under oath and you're a juror and you're sitting there hearing it, it also requires you to do something. You have to assess credibility. Do you believe this? So they're weighted equally, they're valued equally, but oftentimes we might explain or argue as attorneys before a jury. You heard nothing but direct evidence, which means witnesses were getting in there and telling you what you're now using as your blocks for your evidence. And other times they'll try to devalue it by saying everything here was circumstantial evidence. It's just circumstantial, which means it required your inference. But they both can do the trick. They both can prove the point. They both can meet the standard and the burden that someone might have to carry at trial as to an element or a defense. So the main difference just is if it's coming out of witness's mouth or there's some type of inference that the jury has to make.